what about privilege review? For a reviewer, understanding the substance of the case, the names, the terminology, to make that decision about whether a document is privileged is a lot of work. I mean, that's an undertaking. To understand whether it's privileged is a whole different set of questions and analyses to go through. It's a lot to ask one person to do both. How do you address that?
The best way to streamline the privilege review is in every instance where the reviewers are looking at documents to code for relevance and responsiveness and subject matter and all that. They're also coding if there is a potential privilege involved. So whether it was early on, it was indicated as a work product document, or if there's something on the face of the document itself that raises an issue about its privileged status, there would be a field that they would click that would state that it's potentially privileged. Those documents would be segregated from the ones that have not been marked that way, and those documents, the ones that are marked as potentially privileged, would be further reviewed by a set of reviewers who have had extensive training in privilege as it applies in that jurisdiction.
I think it is to make that initial privilege cut over-inclusive, to make sure you're not missing anything.
That's
correct. Now, what do you do for that separate privilege group? What kind of materials or training would you give them?
They would receive all of the same training that the reviewers received. So they would receive all the training on the facts and the people involved and the terminology at issue. In addition to that, they would receive training on the privilege in the jurisdiction that the matter is pending in, or whatever privilege laws apply to the litigation. So, which would usually be in the form of a memo that would set out the various laws. And the memo really could be a template. We have created a template that sets out rules of privilege. In federal courts, the privilege is pretty standard across the board. States vary, but again, when you're at the point when you're revisiting this issue for a particular litigation, you'll want to refresh the law, you'll want to take a good look at what's current in your jurisdiction, and you'll want to update the memo.
Right. I imagine the memos from earlier cases, even though it may be a different jurisdiction, it also functions as sort of a checklist to make sure you're covering all those issues.
It does. I mean, the real benefit to having the template is to be able to leverage work that was done previously. Right. It lays out an exhaustive list of issues to consider when preparing materials for your particular privilege training that you're doing at the moment. So it's really used as a precedent.
Okay. And now this is all working towards a privilege log. Is it possible that as the reviewers go through the log, if they can confirm that it's privileged, is there a way to simply sort of download that to a log? I mean, what's the process at that step?
Yes, the coding fields are set up so that they can be converted straight into an Excel worksheet or any other type of document, so that all of the information is captured for the particular document, and a privilege log can be generated with just slightly more work in editing. Yeah. It can be finalized. And so much of the work that's being done on the database at the time that the actual privilege issues are being decided will be captured and retained so that it can be exported out to a privilege log, which in these times with such voluminous amounts of material, privilege logs have also become quite voluminous. Yeah,
and you know something, that sounds like the privilege log would be almost ready to go as soon as a privilege review is done, which is going on at the same time as a substantive review. Sounds like you can avoid a lot of motion practice over the logs being late, or perhaps even sanctions in a court if you haven't produced the privilege logs. All right.
That's exactly right. There are very few court rules that specify the time period within which a privilege log has to be served. And it's usually within a reasonable amount of time after production is made.
Right.
You know, some courts look at that very strictly, and they want it either at the same time or within 14 days. If you want to be right on top of it all and avoiding motion practice, it really makes sense. The institutional knowledge is there at the time, and it would probably be more efficient to do at the same time that review is occurring while all the knowledge is present. So you're absolutely right.
The process itself easier as well.